Mr. Current, you may proceed.
Thank you, Your Honor. May it please the Court. I am Randy Curran, and I appear today on behalf of George Struve, by and through the substitute petitioners Diane Lawrence, Ronald Struve, and Paul Struve, 3 of his 4 adult children. The defendants are Perry Struve and Perry's son Clayton, Perry being George's 4th adult child. This appeal involves a petition filed by the substitute petitioner on George's behalf under the provisions of Chapter 235F, Iowa's Elder Abuse Statute, which went into effect on July 1 of 2014. This is only the second case to come before this court regarding Chapter 235F, the previous case being the Chapman case, which has been cited in our briefs. The issues raised in this appeal demonstrate that additional guidance is needed by this court regarding the application of Chapter 235F. There are 2 primary issues regarding incorrect factual determinations made by the trial court requiring a reversal. As this is a de novo review, we are asking this court to review the facts from the trial record and find that, first, George Struve was a vulnerable elder under 235F at the relevant times in 2014 and 2015, and second...
Is the standard of review altered by the fact that the trial judge ruled on objections and excluded evidence?
That's cited, too, in our brief. We feel no. The court has stated in Chapman that these 235F proceedings are a de novo review. They're equity cases. And there are cases cited in our brief that say even though there were objections or rulings on objections, that does not make them, take them out of the standard of a de novo review.
Was there anything about the evidence that was kept out that would affect our determination?
We believe that there was, Your Honor. The court, once we went to a summary judgment proceeding, after appearing before 3 other courts, Judge Lawson made a determination that this was a summary proceeding, that there would be no further discovery, that we were inappropriate in having done discovery and having taken as long as we were to bring the matter to trial. So we were basically forced in a very short period of time to bring the matter to trial without being able to depose any of the relevant attorneys that were involved, and I'm sure there were other issues that we would have been able to try and do discovery on. We went into that trial without knowing what many of the witnesses were going to say. So that's probably a long answer to your question of yes, there would be additional evidence. But we feel that even...
But were there objections that were sustained that kept out evidence that was attempted to be offered?
We feel the record reflects that when we asked for continuances for additional discovery and to amend the petition, the record reflects that the trial court judge stated that this was a summary proceeding.
I think we're a little bit ships passing in the night. I think what we're interested in is when there were objections at the trial, during the trial, and the court ruled on those objections, was there evidence that was actually kept out that therefore by those objections that's not in the record that might impede a de novo review?
I don't know that it would impede a de novo review. There could be evidence. We don't know, since we weren't allowed to do discovery. We don't know what would have been discovered. We tried to get access to the attorney's files for the attorneys who had done work for George Struve. We were denied access to those files. We don't know what those files would have said. We don't know what relevant evidence might have been presentable to the court regarding that. The estate attorney for Mr. Struve's wife, we were not allowed access to that file to know what evidence or what correspondence there might have been between George Struve and the estate's attorney, which could have played a role in determining or showing additional evidence of certain mental incapacities which he suffered from.
I kind of think we're talking about something, that we've got the cart before the horse. I can't get beyond the fact that I'm hearing the words trial and discovery in a 235F. I mean, this is, I compared it to 232 or 236, and it's almost exactly the same paragraph for paragraph. Don't you agree with me that it's intended to be a very quick grab at either a judge's attention to either give this person a protective order or not? And anything else that you're looking at, it sounds like perhaps another day, another proceeding. But it seems to me that this little, this short chapter, which I think most district courts consider to be kind of an emergency type tool, has been expanded well beyond perhaps the legislative intent.
Well, the legislative intent was to provide an alternative course for Iowa's seniors. And this chapter is much broader than your 236 application that you're looking at. I've reviewed the 236 language. I agree with you. The language is quite similar on many of the code provisions.
It's almost identical.
Unfortunately. But the 235F is a much broader. It covers physical abuse, it covers emotional abuse, it covers sexual abuse, and it covers financial exploitation. It is a big tent statute. It covers all different kinds of abuse that can be inflicted upon seniors.
All of those things are also, there's 236S for sexual abuse. That has all of the same qualifications, and it's the same short version. And financial could be a form of abuse that a person might be seeking a protective order because of financial, whatever it may be, fear of cutting them out of their home to live in. My point is, when you're saying you're not seeing much case law on it, could it perhaps be because you guys are trying to use it in a manner that's not normally used?
I would disagree with that, Your Honor. I mean, that's certainly the court's prerogative to enforce it that way, and you will probably give guidance after this case as to whether that's the way to imply this case. But in looking at Chapter 235F, the words summary proceeding are nowhere in there. There are no time standards if the court grants a continuance.
There's the word emergency proceeding, and then there's the word 5 to 10, no less than 5, nor more than 15 days for hearing. So that tells me they intend for this to be a pretty tight ship. And also, I want to touch on the fact that you're asking to bring in parties, and you said that would help your client, correct? Was it you that were requesting?
Are you referring to the reference of allowing an amendment to add a limited liability company as a party?
Also, I believe so. I think you also wanted to bring in, that's right, the company. You wanted to bring in another party, and part of it was, you said, to protect the client so he wouldn't have to go through so much litigation.
Basically, this case involves the farmland of Mr. Struve, and his grandson leased that farmland for below market rates. Those leases
I'm aware of the facts.
Okay. The trial court judge said we couldn't make a limited liability company a party, but the statute does provide for money judgments, which is something that is not allowed in Chapter 236. The ability to get a money judgment in this case for an inappropriate lease should be against a limited liability company because they were the holder of the lease. Mr. Struve, Clayton Struve, shouldn't be able to hide behind a limited liability company which he basically could assign this lease to.
And reviewing it, I may agree with you on that point, but my overall reaction in the case is it's very fact intensive, and there was a trial, and at the end of the trial, the district court found for the other side. If we agree with those findings, assuming it's de novo, or find that they're supported by substantial evidence, if it's at law, then it's irrelevant whether you were or weren't able to bring in the LLC, isn't it?
On that issue, it probably is. But again, if you determined that we were not able to present sufficient facts to have George Struve first be found to be a vulnerable elder and then found to be an elder who was financially exploited, we were given a very compressed period of time to prepare evidence to present to the court. We feel that there was more evidence. There were tax returns. There would have been a testimony from accountants. Our arm basically was tied behind our back when we tried this case.
I mean, there are other causes of action besides 235F that are available where you don't have a hearing within 15 days. It's a year or two or whatever.
And we obtained approval from the original judge who appointed the guardian ad litem for additional time. And that judge and two judges after that knew discovery was going on, knew that the matter had been drug out. Mr. Struve had been removed from his home, so the threat of financial exploitation had been stopped. so that we didn't need an immediate remedy in this case. We needed to get him justice for what had already happened to him prior to the filing of this of the 235F petition.
On the issue of financial exploitation, my theory, or your theory as I understand it, is that this was an undue influence situation, and the statute requires proof that the transactions were contrary to Mr. Struve's, or I'll say George, since they're all Struve, yes. George's best interests. I understand the leases were below market rate and the transfers of property may have been against his financial best interests. Is there any indication that they so impaired his finances that he was unable to care for himself or provide for himself in any way?
Financially, no. There's no evidence of that. This is not a case of that form of elder abuse. No, Mr. Struve's day-to-day needs were being cared for.
So, and the reason I ask that question is, within the meaning of the statute, if his interest here was to preserve the family farm and make sure that either his son or his grandson was continuing operations of this family farm, is it contrary to his interests, even if he and ultimately his estate are taking a financial hit if it achieves his ultimate objective of preservation of the farm?
No, if he did that of his free will and accord. But it was definitely shown that Mr. Struve was suffering from dementia. Mr. Struve's...
Yeah, but here's the problem I have with that, just reading the record quickly, and I think probably Judge Lawson had a problem with that, is after the date when he gifts the farmland to Perry and to Clayton, one of your clients goes and borrows money from him. Now, how do you square that to be borrowing money from someone that you claim at the same time was not competent to engage to manage his own business affairs?
He intended to pay it back, is what the difference is. To borrow several $1,000s and intend to pay it back is significantly different from gaining title to millions of dollars worth of farmland. And I'd like to yield the rest of my time.
Is it disputed that his intent, even before dementia, was for someone in his family to continue the family farming operation?
Mr. Struve's will, the joint wills that he and his wife had from 1998 through 2015, specifically provided that his land would be divided 4 ways between his 4 children. And it was only after his wife's death and after he exhibited more dementia that there was a change made there.
I know you want to yield, but I want to ask a question. It seems like everyone's talking about the farm and intention and all that business, and I can't get beyond the fact that 235F has to do with the protection of a vulnerable person. And you just said that the plaintiff was removed from the environment and there wasn't any risk, and that's how come it got extended so long. Doesn't it seem like game over at that point? And perhaps it makes a lot of sense that this case was dismissed or that it should have been, and you go take your action elsewhere? Because it sounds like that's what the issue is the farm.
Well, that was Mr. Struve's primary financial asset. And 235F actions allow for damages. And that's how you get the damages, by bringing the 235F action. The purpose and goal of 235F was to allow procedures like this. And so that's why we feel that when they add the damage component, yes, it makes it a whole different ballgame than in a domestic abuse case like you're talking about. And I'd like to give a little time, or what little time I have left, to Mr. Donnelly, the guardian ad litem.
Mr. Current, thank you. Mr. Donnelly, could you put 4 minutes on the clock?
Thank you, Your Honor. May it please the court, counsel. On September 13, 2016, I had the opportunity to meet with George Struve at a nursing home in Clinton, Iowa. At that time, I observed significant impairment in his mental functioning. He was unable to identify any attorney that he'd worked with previously, was unable to identify whether or not he had a will, was unable to identify all of his children. At around that same time, I sat down with the substitute petitioners in this case to introduce myself and learn what I could from them. Quickly became apparent to me that the respective parties in this case had a abyss between them as far as their points of view as to Mr. Struve, excuse me, and his assets and his treatment. I'm here today primarily to discuss the district court's refusal to hear the entirety of my testimony at trial. I'm sure that the court is aware that 235F.5 provides that an allegation of elder abuse can be proven by the testimony of a guardian ad litem. In this case, the court did entertain a portion of my testimony. However, the entirety of it was only made available to this court via an offer of proof that was motivated by the substitute petitioners. I would ask the court to consider the implications of that scenario where we have a guardian ad litem appointed with statutory authority to investigate and to testify, but then having that testimony be ignored at trial. I, for one, would not disagree with the district court judge with regard to this underlying statute perhaps having deserved a little more time before it was passed into law. There are some vagaries associated with it that I think the district court did a fair job of pointing out, but at the end of the day, my concern is that Mr. Struve and his best interests were not given a full hearing. While this issue was obviated to some extent by the fact that I was permitted to make an argument, that argument was not recorded. The remainder of my testimony, as I set forth earlier, is available for review due to that offer of proof. I would ask that the court review that and give it the weight that you think it deserves, rather than simply ignoring it as was done in the court below.
As his guardian ad litem, on the day of trial, was your client a vulnerable elder on that day?
On the day of trial, I believe that Mr. Struve was a vulnerable elder.
Was he still living on his own, or was he living, I think the other attorney mentioned that he was living with other people and no longer at that point vulnerable?
On the day of trial, Mr. Struve was at the Eagle Point Nursing Home in Clinton, Iowa.
So do you think he was vulnerable on that day as his guardian ad litem?
I believe that he would have been vulnerable to anybody who wished to do him harm. He was dealing with significant dementia at the time.
Mr. Donnelly, thank you.
Thank you.
Mr. Balk.
Thank you. May it please the court, counsel. My name is Steve Balk. I was the trial and am now the appellate attorney for the grandson, Clayton Struve, the grandson of the alleged vulnerable elder, George Struve. Chris Farwell was the attorney for the son. He wrote most of the appellate brief, which we joined in. He's filed a motion to be excused from today, which was approved. The Iowa legislature attempted to right a wrong when it enacted this chapter, but as with many new causes of action, there are some loopholes, some gaps, some boundaries it needs exploring. Primarily, the issue here is that the substitute petitioners are trying to drive a truck through the edges of this well beyond legislative intent and common sense. At its heart, this is a premature inheritance case. George Struve is in a nursing home. He's been in a nursing home since September of 2016. The court had inquired a bit before, why should this be a summary proceeding? Well, George has been stuck, or was stuck, I should say, from September of 2016 until he got done with trial in January of 2018, without ability to go back home, where he was living with his son, who had been taking care of him since he broke his hip in July of 2015. So the substitute petitioners have ripped their father out of the home he had known for quite a long time. When that happens, sometimes a person's mental acuity is affected. Testimony was that George was a private person. It should be no one's surprise that when a strange attorney comes to meet him in a strange place after he's taken by the sheriff from his house, he wasn't the most friendly to talk to. Also, this sort of trauma can cause longer lasting effects, which may be evident as the Dr. Trinnell at the University of Iowa Hospitals, who's a PhD, not a physician, testified to in some part. This is just a typical farm family. There's George Dolores, 4 kids. One kid stays close to home, wants to become a farmer. His son, born in 1992, raised a lot, in part by the grandparents, grows up on the grandfather's knee on the tractor, also wants to be a farmer. It's a century farm. George wants to make this century farm continue. George wants Clayton to be the farmer. George wants Clayton to have some advantages. No one else, whether it be kids or grandkids, is a farmer or is going to be a farmer. Farming is a business like anything else. George Struve was trying to make sure that the next generation of Struves, the third generation, if you will, at least from him, had an opportunity to do so. The fact that the substitute petitioners really see no value in maintaining a family farm is relevant, but not really to George. George...
The whole theme, as I'm hearing it, is we have nothing to hide. There was nothing unusual. So why not let the guardian ad litem have access to Mr. Bartelt's files?
Well, Mr. Bartelt testified, Your Honor, as did 2 other attorneys that day.
I know, but you know, it sure helps if you have the files, right?
It does. That motion was made rather late. We objected, and then the court ultimately sustained the fact that the files themselves would be excluded from discovery, although he brought the file with him. It was quite thin. However, he did testify fully and fairly, as did another attorney from his firm, as did Mr. McGee, who was the attorney who handled the estate and was involved with Mr. Struve earlier in the case. Mr. Struve had a 4th attorney yet who attended the family mediation. He wasn't called to testify. The mediator, retired Judge Nara of Scott County, wasn't called to testify either. There are certain people who could have testified in addition to things, but the attorneys who met with Mr. Struve were consistent with 2 points: that Mr. Struve was competent when he talked with them and they made their plans. He was also consistent that he wanted this farm to go on, and the person had to go on with was Clayton.
What do we make of this somewhat unusual circumstance? Reading the file, I may be wrong, that Mr. Bartelt represented Mr. Struve in connection with the farmland transfers, but Mr. Bartelt's associate, meanwhile, was representing Clayton and Perry in connection with some aspects of dealing with George. Isn't that kind of a conflict of interest?
Well, it could be construed like that. In fairness, though, I would say that it appears the associate's role was limited more or less to setting up the limited liability company in April, which was then put through the state of Iowa in May of 2015. It doesn't appear that the associate took any role between Clayton, my client, or the LLC and George. So the court can certainly feel free to discount some of the testimony if it wishes from Mr. Bartlett, but Mr. McGee was also consistent on these same points.
When was the first below market rate lease entered into, if the record reflects that?
Sure, the first below market lease would have been entered into before Dolores passed away. Mr. Struve began farming, if I recall correctly, for crop year 2012, which is typically signed in the fall before that. Dolores, who kind of ruled the roost, as everyone testified to, passed away in April of 2014. That lease would have been in place for 2014 before she passed. Then the 2015 lease was only entered into after the family mediation, at which Mr. George Struve had his own attorney, and the mediator, retired Judge Nara, was there, Mr. McGee was there, all the substitute petitioners, Clayton and Perry. So that's really the correct timing. The 2016 lease then was put together after the limited liability company was formed. But this goes back even before Dolores passed, trying to get Clayton into farming. Clayton was only born in 1992. I don't think it's fair to expect that George would have anticipated in 1998 that Clayton was going to become the farmer and need to keep his will the same all the way after that. The substitute petitioners have made a great deal of the fact that George is a vulnerable elder. The problem with that is that the substitute petitioners only deem George a vulnerable elder when they need him to be. That is, if he's a vulnerable elder, why is one of them borrowing money and signing a note with them? If he's a vulnerable elder, why are they going and getting 2 powers of attorney for him to sign? Here,
can't we infer some level of diminished capacity, at least, from the fact that George is changing the power of attorney so frequently between the children over that 2 or 3 month period of time?
Well, if the court does, it's a far cry from that to saying either he's incompetent or if there's undue influence by either George or by either Perry or Clayton after that. But the testimony of 3 attorneys and 2 bankers, 1 neighbor, 1 sheriff's deputy, the contemporaneous medical records all testify to the fact that George was in good health and knew what he was doing when he made these decisions. By contrast, really the plaintiff, substitute petitioners, I should say, are relying upon 1 professor who's not a doctor who examined him more than a year after any of the issues in question came up and after he'd been forcibly removed from his home. He gave us a retrograde diagnosis, trying to go back. He admitted that dementia progresses in fits and starts. So here's an average person. That really can't be applicable to George. Maybe he was better, maybe he was worse, maybe he was unaffected. That doctor doesn't know. The family physician, his records show otherwise. The nursing home, those records show otherwise. Mr. McGee said that George's primary concern was not financial, that's George's words, and that George wasn't focused on money. Mr. Bartlett said that George wanted to change the entire estate plan because Clayton Struve needed more capital to survive, and George wanted to keep the family farm going yet another generation. If George had diminished capacity, well, he still had a driver's license. He still got elected to and was serving as the township trustee. He was able to execute a note to the substitute petitioners and do 2 powers of attorney for them. He participated in the family mediation in February of 2015. He acted as the executor of his wife's estate, which didn't close until mid-2015. The substitute petitioners never sought a conservator, and when one of the substitute petitioners called the sheriff out there to do a wellness check, the deputy said that Mr. Struve was of sound mind in February of 16. There's really no amount of evidence that's going to satisfy the substitute petitioners that Mr. Struve was of sound mind, which is different than undue influence. I understand that. The problem is that realistically, by their standards, anything you do once you're over 60 is challengeable, because even if everybody you deal with thinks you're of sound mind, a doctor a year and a half later says, hey, he might have had dementia back then, let's throw it out. That's really no way to conduct business or to conduct a life. The issue of undue influence arises if he's found to be a vulnerable elder, but in this case, I don't believe either of the defendants made George do anything he didn't want to do. His estate would be diminished through the life estates granted, but he still owns all the land. He has all the money he needs. He's in care in a nursing home. There is no possibility of abuse. A conservator was appointed well before this order of protection was ever filed for. In short, by the time the order of protection was filed for, financially, no further abuse could happen. There was no allegations of physical abuse. Despite that, he got removed from the home he'd been in for over a year to go to the nursing home. We contend that his health deteriorated because of that. These need to be summary proceedings because someone's liberty in this case is at stake. Mr. Struve had his own attorney who didn't really take a position on much. Mr. Struve had the guardian ad litem who went out and investigated. There are essentially 3 kids against 1. These inheritance cases used to wait until after the funeral, but for better or worse, this chapter kind of sped up the process. There was a question as far as attorney-client privilege. This chapter says nothing about the waiver of attorney-client privilege by anyone. Instead, the court had to find someone incompetent.
This chapter also says nothing about discovery or anything like that, so I don't think you can hang your hat on that. I'm still trying to get my head wrapped around the fact that I'm hearing all this talk about land and wills and inheriting and and I want to get back to the point. If you say your client, or Mr. Struve, was not vulnerable, did you have any concern about it lasting for a year? What action did you take to try and make this case go away? I mean, there should have been a guardianship and conservatorship proceeding instead, it seems to me.
There was a conservatorship proceeding that was actually in place and has been in place this whole time by Clinton National Bank.
Was that in place at the time the application was made alleging elder abuse through financial?
That's correct. The limited guardianship was in place back in July of 2016, as the record indicates. And this was not filed until September of 2016. But the quick answer is why Clayton, my client, didn't really do anything is because the allegations were primarily, really, at the time when they were seeking everything against his father, Perry. They were seeking to go back all the way to 1985, as far as discovery, to get documents from him. Well beyond even the initiation date, or the effective date of the statute was July 1 of 2014. So because of that, it was in Clayton's best interest at the time to sort of allow Perry to steer the boat. Clayton wasn't being prejudiced. His father was, but Clayton felt that best to sort of leave his father and the attorney there, too, to make some decisions about that. The problem, though, is that this is indeed intended to be an emergency procedure. If he's safe physically and if he's safe financially, really no further harm can be done. There are a lot of other remedies that they can pursue as substitute petitioners, but it's not really they as substitute petitioners. It would be the conservator, typically, or his heirs afterwards. They get no additional rights. They can't bring a case for a car accident. They can't bring a case for a bad check writing, for a slip and fall. They're substitute petitioners solely in the sense of the elder abuse chapter. And the court did not abuse its discretion when it refused to allow them to add any additional counts. Further, the court did not abuse its discretion when it refused to allow them to add a limited liability company as someone against whom the order of protection was sought. Why is that? Well, primarily because there has to be some sort of confidential relationship between the defendant and the party. Here, this limited liability company was formed in April or May of 2015. There was a lease done in September of 2015. That's it. How can an 86-year-old person form an attachment or trust with the company? With Clayton, sure. With Carson, even, for sure. But with the company, it would be unusual.
The argument is not that per se an LLC can't be a defendant. It's just in this case they shouldn't be.
No, I think the legislature recognized by excluding a lot insurance companies, banks, insurance brokers, that sort of thing, from being in that confidential relationship. That there are other entities could be sued. I would have perhaps used a word besides persons in that paragraph, but nonetheless I would concede that other entities may be sued under that.
The more somebody wants some documents and the more you're told, like, for example, the information they wanted to receive through the guardian ad litem, the more they're told no, perhaps the more they want it. And I think there's some logic to that. You're saying this is what George wanted, and it seems like a pretty simple way of perhaps putting that to bed. Do you still today believe that the guardian ad litem cannot stand in the shoes of George and request to have that conversation, that candid conversation with the attorney?
Once the court, it would be my opinion that once the court determined as of the day of the hearing that George was incompetent as opposed to being a vulnerable elder, then the guardian ad litem could, not the substitute petitioners, but the guardian ad litem could step in there and waive attorney-client privilege, which he did do. I think the matter of the missing documents as opposed to the missing testimonies, there's no missing testimony by any of the attorneys, was more a matter of it being brought too late as opposed to it necessarily being improper per se. I don't know what the records say, nor does anyone else. I can say the folder they were brought in was quite small. There could be a pot of gold in there as far as evidence. I find that unlikely. The attorneys all testified. The court found them credible, and I would think it unlikely that there's something in their writings that they would have testified inaccurately as to. For all those reasons, we would simply request that the district court's determination as to all aspects of this case be affirmed and that the matter be settled. Thank you.
Mr. Balk, thank you as well. Mr. Curran.
Thank you. Several issues that were brought up by Mr. Balk I think need to be addressed. One is the opinions of Dr. Trinnell regarding the lay witness testimony. I think that it's very important that we listen to what the head of the Department of Neuropsychology at the University of Iowa says about lay persons being able to diagnose or to acknowledge and know when somebody is suffering from dementia. He basically talked about when you are around a person with dementia for short periods of time, it may not be obvious. But Dr. Trinnell was trained in how to examine those things and evaluate those things. That was all discounted by Judge Lawson, and I think that we're asking this court to review Dr. Trinnell's testimony because he answers and addresses the issue of the lay witness testimony. Mr. Balk tried to minimize the legal activity of Clayton Struve's lawyer. Clayton Struve's lawyer terminated the initial lease after George Struve came to live with Clayton and his father, Perry. And then shortly after that, Clayton Struve's attorney drafted a new lease, which George signed without any legal advice, any family advice. All of these actions were taken in secret. No one else was consulted. Clinton's attorneys in Clinton were not consulted. He was basically hauled to a lawyer 40 miles away from his house and presented these documents to sign in secret.
I think you've given some excellent reasons why there should be concern, and I don't want you to think I am downplaying the facts, but do you think this was the appropriate avenue? Do you think this 235F is the way to get to what you're talking about?
Yes, because the legislature determined that financial exploitation was one of the avenues to prove elder abuse, or one of the types of elder abuse. And they also provided that damages could be awarded so that it meets the category. All of the transfers which were done before the filing of this petition. They were all done before Mr. Struve was taken into a bank without the knowledge of anybody else in his family and entered into a voluntary limited conservatorship. The limited conservator wasn't known about at the time this petition was filed. When the limited conservator was discovered, the limited conservator did not desire to have any part in this proceeding. If the assets are returned, if there is a judgment that's awarded, it goes to George Struve. The substitute petitioners are not the ones that are on trial here. It's the defendants. If there are any judgments that are awarded, if there are any assets that are returned, they're returned to George Struve. And they're his to do with as he may well have decided in his testamentary plan. But there was too much secrecy going on here. And that has been an element of undue influence under the common law. And that should carry over into this statute. When you look at the change of a long-term testamentary plan.
I'm back you up a bit. Do you agree with me that the statute is for purposes of protecting people from either physical or perhaps sexual, if you don't use the other statute, or financial abuse?
Correct.
And would you agree with me that vulnerable elder is defined as someone who is unable to protect himself or herself? And I think the evidence shows that there was already a conservatorship in place, correct?
There was a limited conservatorship that we discovered after the filing of the petition.
So a conservatorship, if somebody takes advantage of someone under a conservatorship, I think we all know how that plays out.
But there was also a remedy. And Mr. Struve's remedy is available under 235F to right the wrongs that were already done before the filing of this petition. Mr. Struve, George Struve, from the time of the filing of this petition, has been in a senior's facility. Mr. Struve has never appeared in court. Mr. Struve has been incompetent from the day that this the petition was filed. His lawyer never asked for him to be removed from the Eagle Point Nursing Facility. His guardian ad litem has never asked for him to be removed from the Eagle Point Nursing Facility. Dr. Trinnell testified that it was in George's best interest to be at the Eagle Point Nursing Facility.
Can you address the fact that the below market rate leases started, I believe, before Dolores died? Wouldn't that indicate that at least at that point in time, there was some indication by the parents that they wanted to allow the family farm to continue?
It could also indicate that we had an elderly couple in poor health, and it was their son and grandson who also lived on the farm in another residence who allowed them to live on that farm. And there's no doubt that George and Dolores probably wanted to help Clayton. And so that's why all of the family agreed that Clayton was to have a below-market lease for 2 years. And that lease was terminated after the first year without knowledge of anyone else in the family, and after George went to live with Clayton and Perry, and was extended so that the drain was allowed to continue. So that, yes, that's not unusual, as has been pointed out, to try and help somebody. But to continue it, to get all of that in place, and then say, okay, now we're going to also give you the land, that's something completely different. What started out as an under market lease turned into a gift of over 300 acres of farmland in secret. We would ask that the court reverse the findings of fact by the trial court that George Struve was not a vulnerable elder and that he was not the victim of financial exploitation. We feel that more than sufficient factual evidence has been presented in order to meet the burdens of proof that were required of the substitute petitioners. If you feel that the burdens of proof have not been met, then we would ask that the matter be remanded for a new trial. But if you feel that the burdens of proof have been met, we would ask that you reverse the trial court and send this matter back for the issue of damages. If we've met the initial burdens, that he was a vulnerable elder at age 86, and that he was also financially exploited, we don't have to go back and rehash that, even if we were forced to try this matter at a severe disadvantage. But we should be able to then go back, put on additional evidence regarding the issue of damages. The trial court probably did get that right when they did that in a bifurcated manner. Chapter 235F was passed for a reason. The reason was to protect Iowa's elderly population. It's a big tent statute, as I say. You have to allow it to work. Does it need some clarification? Without a doubt. But you don't throw that whole statute out because it needs some clarification. Thank you.
Mr. Kern, thank you as well. Mr. Donnelly, thank you. And Mr. Balk, thank you again. The case of Struve versus Struve is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.